From the historic campus of Hillsdale College in Hillsdale, Michigan, where the good, the true, and the beautiful are taught, nurtured, and honored, this is the Radio Free Hillsdale Hour, bringing the activity and education of the college to listeners across the country.
As Hamilton points out, something like a Bill of Rights is really appropriate for a monarchic government, not for a Republican government. And he says, why are people calling for a Bill of Rights? He says, well, because under the British we had Magna Carta. Because under monarchic rule, the assumption is all power resides with the king, and any exceptions to that you need to state on paper.
This is your host, Scot Bertram. Welcome to the Independence Day edition of the Radio Free Hillsdale Hour, part of the Hillsdale College Podcast Network. That was Dr. Ronald Pestritto, Dean of the Graduate School, Professor of Politics, and Charles and Lucia Shipley Chair in the American Constitution at Hillsdale College. We begin our conversation as we focus today's episode on the United States Constitution. Dr. Pestritto, thanks so much for joining us.
Happy to be here. Thanks for having me.
We're inviting you today to enroll in Hillsdale College's free online course, Constitution 101. Go to hillsdale.edu/course, scroll down to featured courses, and sign up for Constitution 101.
Dr. Pestritto teaches 3 of the classes offered in Constitution 101. We'll talk about those in a moment. But the big question, why should people go sign up? Why should people do it? Why should we study the Constitution?
Well, one sad fact there is it's not done very much anymore, and I think lots of folks realize, not only those who are undergoing their education presently, but people of all ages seem to be understanding that something is missing in many ways from their own education, and so we're trying to fill in the gaps that have been left, I guess you can say, and more seriously, I think it's the case in the country today that most people, even people who consider themselves relatively well-informed and educated, people who keep up on things, they realize they don't really know much about what the Constitution set up for how government is supposed to work. And the reason is because so much of the way policy is made today does not reflect very well at all the original vision of our founders. Policy today is made either by bureaucratic agencies or by federal courts, where you have litigation that all the big legislation seems to end up in these days, and neither of those institutions are elected. Neither of them were intended by our framers to be the principal policy-making organs of our government, yet those that were originally intended to do that, the Congress, the presidency, there's so much paralysis that these other institutions have taken over. And so people, I think, need to understand that and need to understand why that's different from the original vision. And more important, what problems might come from that fact.
The course is taught by a number of our Hillsdale faculty. Dr. Larry Allen, our president, is also involved. You teach 3 of the courses in this Constitution 101 series. Which ones do you tackle, and what should people expect to kind of learn?
Well, I've got a couple from the founding era, so they kind of got me on both ends. I've got a couple that deal with what was the original vision, and we talk about, for example, the problem of majority tyranny and how the founders very keenly saw that during their time and what they did to try to mitigate against it. We talk in particular about the separation of power system, and that's the original kind of blueprint for how the institutions are supposed to relate to one another. And so we set that up. We talk a lot about the Federalist Papers, in other words, which is the great book that was written coming out of the Constitutional Convention to sort of explain the design of things. And then they bring me back in at toward the end to sort of talk about what happened.
Sure.
And this is an area that I've actually spent a lot of my own scholarly time writing about. I talk about the Progressive Era for the most part, which was really the first time in American history where you had an open and direct criticism of the Constitution by the most important intellectuals and politicians. And that really was kind of springboard for the rise of modern liberalism. And so I've kind of got both sides of the equation, sort of the establishment of the original vision, and then kind of an account of, well, what happened to it.
Dr. Ronald Pestritto with us. He's one of your teachers for the Hillsdale College free online course, Constitution 101. Go to hillsdale.edu/course and scroll down to featured courses. Sign up there for Constitution 101.
When we think about the Constitution, what's the relationship between the Declaration and the Constitution?
Sure. I mean, some of our audience may know a president of a certain college who's written a book about that topic.
Yes.
So of course we have to direct people in that way. But a sort of a short version, right? The Declaration comes first. The Declaration we like to think of as the document that announces our independence as a people, and it states the purposes of the country. Why are we coming together as a people? What principles are there that we dedicate ourselves to? And that's where you have the discussion about human nature and what human beings are and what form of government is most fitting for human beings. And this is done to sort of compare against the actual practice of government in North America at the time by the British. And so that's one might say a document where we dedicate ourselves to the principles of just government for all human beings. Then the particular question becomes, well, how specifically do we make arrangements in order to achieve these principles? If we want a government that is operated on our consent, if we want a government that secures the rights that we have by nature, God-given rights that we have by nature, okay, well, how do we structure it? And of course, we give it a couple of tries.
Yeah.
Our first Constitution, properly so called, is this thing called the Articles of Confederation, and of course that's a first attempt that doesn't go very well. And so the Constitution comes out of the convention in 1787. Is our attempt to do a better job of it and to think more carefully about, well, what powers should be given to the national government, what should the relationship between the states and the national government be, and then within the national government itself, what should be the institutions and what should be their mutual relations. And so I would say the Constitution is about what Alexander Hamilton calls the science of politics. What are the prudential means of government required to achieve the Republican ends that we've already dedicated ourselves to in the Declaration of Independence?
Why were the Bill of Rights not included in the original Constitution, and should we think about them any differently because they were not?
Yeah, it's a great question, and it's a really very interesting one, because if you ask most people to talk about some part of the Constitution that they know,
right,
almost always it's going to be from the Bill of Rights, the thing that actually wasn't in the original Constitution. It's very, very interesting. And most people know their rights from watching cop shows on television or something. Hopefully no one's ever been read their rights. But in any event, you're quite correct. It wasn't part of the original. And the reason is, and there's a wonderful Federalist paper on this, the 84th Federalist paper written by Alexander Hamilton. The reason is, as Hamilton points out, something like a Bill of Rights is really appropriate for a monarchic government, not for a Republican government. And he says, why are people calling for a Bill of Rights? He says, well, because under the British we had Magna Carta, which was this listing of rights against the British Crown. And Hamilton explains, well, and very appropriate, because under monarchic rule, the assumption is all power resides with the king. And any exceptions to that, you need to state on paper. And that's what Magna Carta was. And so the more exceptions you state, the more liberty you have, because what is not specifically protected, the assumption is the government can do it. And Hamilton explains that's all well and good, but that's not our system. In a Republican system, the assumption is all power resides with the people themselves. And the government doesn't have any power unless it is explicitly given over to the government. And so there's no need to make this kind of specific reservations of rights that you would have in something like a Magna Carta, or what ultimately becomes a Bill of Rights. Furthermore, as Hamilton explains in the 84th Federalist paper, it could even be kind of dangerous, because if you lay out a specific listing of rights then the automatic assumption is, well, if some right isn't protected there on paper, then the government must have the power to transgress. And of course, that's not the right way of looking at things. It's a very dangerous way of thinking for a Republican people. And ultimately, the bottom line for the Federalists was, if you want your liberty protected, there are two ways to go about it. One of them is to write a bunch of rights down on paper, and they didn't have much hope for that because they had seen it fail in the States, for example, and they called these restrictions mere parchment barriers, worth the paper they're written on. Or you could actually design a government smartly, prudently, set up its institutions, set up its arrangements so that it was unlikely to violate people's liberties. And that was the route that they took.
How far have we drifted today from the original design and the purpose of the Constitution?
That's a very open-ended question.
Yes.
And I think the answer is quite far. The situation is we still operate under the legal framework of the Constitution, but we have had decades and decades and decades of a kind of progressive political culture that has taken over, and it thus tends to make the kind of picture in American government very incoherent and muddled, because you still have to sort of adhere to the black letter law of the Constitution, or at least pretend that you are doing so. But all the while we proceed as if these forms of the Constitution mean something different than what in fact they pretty obviously did mean to the framers. And so it's a mess, and we really have deviated today. And I think you can see it, especially in the way in which most policies are made today, as I alluded to in our introduction, not by elected branches of government, but by agencies that are set up. They're set up not to be accountable to anyone who's elected. That was part of the original idea when they were formed, and then they usually end up getting fought over in the federal courts, as you've seen recently with lots of policies now. Anything President Trump does, he gets sued. By the way, this was the Republican strategy under President Obama. So it's not the sole possession of one party. That's just where we are, and it's very, very different than the original plan, to say the least.
Dr. Ronald Pestritto, if you want more of him and more about the Constitution, we invite you to sign up to take the free Hillsdale College online course, Constitution 101. Go to hillsdale.edu/course, COURSE, and scroll down to featured courses. Sign up there for Constitution 101. Dr. Pestritto is the Dean of the Van Andel Graduate School of Statesmanship, Professor of Politics here at Hillsdale College, and Charles and Lucia Shipley Chair in the American Constitution. So he's a good guy to talk to about the Constitution. Dr. Pestritto, thank you for joining us here on the Radio Free Hillsdale Hour.
All right, thanks for having me.
Up next, as we continue our special Independence Day edition of the show, we talk with Hadley Arkes, the founding director of the James Wilson Institute on Natural Rights and the American Founding. His recent book, Mere Natural Law, Originalism and the Anchoring Truths of the Constitution. I'm Scot Bertram. This is the Radio Free Hillsdale Hour.
Hillsdale College is a small, Christian, classical liberal arts college that operates independently of government funding, and we want you or your son or daughter to apply. At Hillsdale, students grow in heart and mind by studying timeless truths in a supportive community dedicated to the highest things. Hillsdale College costs significantly less than other nationally ranked private liberal arts colleges and receives regular recognition as a best value, and nearly all students receive financial aid. Our robust core curriculum, vibrant student life, and 8-to-1 student-to-faculty ratio make for an education like no other. For more information or to fill out an application, visit hillsdale.edu/info. That's hillsdale.edu/info.
We're back on the Radio Free Hillsdale Hour as we continue this special Independence Day edition of the show by talking with Hadley Arkes. His recent book is Mere Natural Law, Originalism and the Anchoring Truths of the Constitution. Hadley, thanks so much for joining us.
Oh, thanks for inviting me in, Scott.
Let's do a definition first, just so people are familiar with what we're talking about. Natural rights, it's the basis of the book. Natural law. What is natural law for our audience?
Natural law is the very ground of the law. The law tells you how you have laws and why you have laws. As Immanuel Kant pointed out, before you have a positive law, you have some underlying natural law that tells you why you'd be warranted in having a law in the first place. So you see signs on the highway saying 65 mpm, 35 p.m. There's no moral significance there. But behind them is a deeper natural law that tells you why you'd be justified in having laws that restrain the freedom of people to drive at speeds that put innocent life in hazard. But look, let me get back to the book itself, okay? Because the natural law is a law that tells you in the first place what is a law, and the properties of a law. Actually, it could be a little experiment we could do here. But first, let me go back. The part about mere natural law. I'm drawing on C.S. Lewis. That interesting move in Mere Christianity, where he finds in the conversation of children, the rudiments of moral reasoning. You find kids in an argument. They're not arguing over likes and dislikes. They're arguing about right and wrong. And the conversation makes no sense unless they're already presupposing that their standards of judgment in judging the difference between better and worse reasons. Now, what I'm doing here, and I'm appealing to, as the founders did, to the great Scot philosopher Thomas Reid, about those precepts of common sense that the ordinary man has to know before he starts trafficking in theories. So before the average man would start bantering with David Hume about the meaning of causation, he knew his own active powers to cause his own acts to happen. What I'm trying to point out to people as the main precepts of natural law are things that that ordinary people grasp right away. Not only do they grasp them, but they have to take them for granted in getting on with the business of life. My point is the American founders found the origin of the law there, in those precepts of common sense that were there before the Constitution, the precepts they drew upon in forming the Constitution. And they understood that those principles would be there even if there were no Constitution, much in the way that John Quincy Adams would later say, that right to petition the government is simply implicit in the notion of a free society. It would be there even if it had been set down in the First Amendment. It would be there even if there were no First Amendment. It would be there even if there were no Constitution. So we're trying to take things back to some things that grasped at once by ordinary people that are utterly necessary to the law.
There are some quotes in here that make that point very obvious. You quote your friend Daniel Robinson, who says there, that matters so foundational that we absorb them without the least amount of awareness that we know them. And later you have this example. You said the very ground of natural law can be drawn from precisely the same common sense accessible to children and ordinary folk. You have this great example of a 7-year-old beaten up by friends and what his natural reaction will be. If it is so foundational and so accessible, why do we have concerns and conflicts about natural law?
Because people absorb all kinds of theories that get in the way. Let's take one of the most that point you mentioned about the children. They understand. Remember the choice of what do you think they'd react? How they react if somebody he's beaten up? He'd say he'd have a sense he'd be wrong, feel wrong, or that he would think they must have been right because they succeeded. No one thinks the second one is possible. That is, you assume that the natural reaction is the fact that some people succeeded in beating me up did not show that they were justified and rightful in doing it. But you've got the kids would understand the sense of Rousseau's classic point that the mere success of some people in seizing power over others cannot itself be the justification for that power, as though brute power forms its own justification. Now, the kids who understand something that evaded Justice Holmes, Because when Justice Holmes was asked, what is the ground on which the majority rightly governs the minority? He said, because the majority can overpower the minority, which is to say, the rule of the strong, might makes right. But the other one, and thanks so much for drawing on Dan's piece, Dan saying he wanted his tombstone, he died without a theory, but let's take the things that are accessible to people at once. You give the ordinary person, if you permit me, Scott, you were kind enough to actually draw nice passages for the book. If you give the ordinary man this proposition, that Jones, accused of a serious crime, happened to be in intensive care following surgery at the time the crime was committed, I think the ordinary man will wonder, why are you prosecuting? Which is to say, the ordinary man backs in to that precept of common sense that formed the first principle of moral and legal judgment, as understood by Immanuel Kant and Thomas Reid, that it makes utterly no sense to cast judgments of praise or blame on people for things they were powerless to affect. We don't hold people blameworthy for things they were powerless to affect. As Thomas Reid said, that would be as true, as necessarily true as any axiom in Euclid. Yet from that simple propositions, we could draw out many other things in our law. The point is, the ordinary man understands that right away. There's nothing mysterious about it. I cite that line from Jefferson to Peter Carr saying, you can give the same problem to a plowman and a moral problem to a professor and a plowman. The plowman is apt to get it right because he's not going to be distracted by artificial rules. Call them theories. What's interesting about, of course, intellectuals, and especially people who've studied law, is that they've absorbed so many theories, many just off the point and misleading, and theories also, in the case of conservative jurisprudence, which have imparted to people a sense that it's a cardinal virtue to try to steer around questions of moral substance as though they're not part of the business of judges.
Some of these theories, some of these conversations sow confusion, and some, as you point out, say the very presence of disagreement on any matter of consequence must mark the absence of truth. Why is that not the case? Why don't people have more confidence in their convictions?
Well, they do. Most people don't think that if somebody disagrees with them, they're necessarily wrong. There's no truth there. This is the line that it's a line that Justice Scalia is why he dismisses natural law, because we can't get consensus on it. Well, his friends used to say, "Did you ever get consensus on that point? That there's no truth unless there's consensus?" Because we didn't get our ballots when you came around to it. But what I point out is that it's what the philosophers would call a self-refuting proposition. It's the very presence of disagreement on any question of major consequence must mark the absence. The way I went this way: if there were these truths found in all places, they'd be recognized in all places. But if they in sparse and wide disagreement indicate that they cannot be true. The very presence of disagreement marks the absence of truth. And as you've seen, what I have to do is record my own disagreement with that proposition. And by its own terms, that's enough for the thing to dissolve, come apart. I record my own disagreement with the proposition that disagreement marks the absence of truth. Now, as I said, this Justice Blackmun, used that self-refuting proposition, which dissolves in 6 seconds. That he used that proposition to form a whole new branch of our law. And in his hands, it went this way. When so many learned people in law, religion, medicine cannot agree on the question of when human life begins, obviously there is no truth that judges are in a position to proclaim. It's a self-refuting proposition. And people fall into these things all the time. Now, my friend Scalia thought he'd get around these questions of these divisive moral judgments by just appealing to the historical record. Is this thing, like the right to abortion, something long recognized, or the right to bear arms? And yet he didn't know what he was confronted persistently by his liberal colleagues who offered their own contentious rival readings of the historical record. And when that happened, it didn't dislodge didn't dislodge Justice Scalia from the conviction that the historical study had truths to offer. And later on, Neil Gorsuch, Justice Gorsuch, told us that, you know what, people who call themselves originalists can actually disagree in their construals. And yet, apparently, nothing in that disagreement, nothing in that want of consensus among originalists establishes the point that originalism has no truths to discern. It's just people just tying themselves in knots over things that really should not be fooling grown-ups.
Hadley Arkes is with us. His new book, Mere Natural Law, Originalism and the Anchoring Truths of the Constitution. I want to ask specifically about this because you say a few times, more than a few times, as you discuss some of the great originalists like Justice Scalia, Justice Bork in the book, but you essentially say, and sometimes directly, that originalism is not enough, that legal philosophy of originalism. Why is natural law needed? Why is originalism not enough?
Well, what we're getting is an originalism that concentrates on the text. It's a truncated originalism that utterly detaches us from the moral ground of the regime. I remember the conference once, Professor Amy Comey Barrett was asked, since she followed Scalia, she followed the positive law. And a student got up to say, well, why are we obliged to follow the positive law? What makes the positive law in America different from the positive law of Stalin's Russia? The difference has to do with how we've established the terms on which we establish who has the rightful authority to make the positive law. Before we know who can enact the positive law, we did start with that principle of what is the rightful governance over human beings. Now, Lincoln, in that first inaugural, had a careful explanation of why. With the rule of a majority under certain moral and constitutional restraints is the only operational form of rule by the consent of the majority, rule by the consent of the governed. You have to start with that. John Locke gave us the key. He said, what is the source of the law? The legislature. Well, what is the source of the legislature? Constitution. It tells you whether you have a legislature, how many chambers. Then he said, what is the source of the Constitution? He says, it must be some source antecedent to the positive law. Now, my friend Scalia would say, this whole thing begins with the notion that the only rightful governance over human beings must depend on the consent of the governed. And he'd say, that has never been enacted in the positive law. And the response was, of course it couldn't be enacted. It had to be that principle of natural law that had to be in place before you could establish just who had the rightful authority to make that positive law in the first place. Mm-hmm. You had to go back to the beginning, the grounds in which you understand what is the rightful governance over human beings. And as a man, you went to ask about natural rights. The argument was at the beginning, remember, no man is by nature the ruler of other men, in the way that God is by nature the ruler of men, and men are by nature the ruler of dogs and horses. So if you find in the world that some men are governing over others, it can't arise from nature. It must arise from consent. No man is by nature the ruler of other men, the way men must be the ruler by nature over dogs and horses. So that even in this age of animal rights, we're not signing labor contracts with our dogs and horses. Mm-hmm. And Jefferson said, in a famous line, well, anyone who denies that truth about those natural differences must assume that the mass of mankind were born with saddles on their backs, and the privileged few were born with spurs on, ready to ride them. Not that what we're saying is the ground of human freedom, that no man is by nature the ruler of others. No man could be the owner of make a slave of another by nature. That is simply grounded in those differences in nature that separate human beings from other animals. And the question is, well, where will that hold true? Wherever in the world that difference in nature remains the same and is sustained. So in other words, we're talking about rights that arise from human beings by nature. We're talking about rights that are grounded in an enduring nature of human beings.
Hadley, there's a long section in the book on moral judgments, and the point you make that I think is stark, and I hope you can just extrapolate out on a bit, is this idea that people think or have this belief that if they are neutral on something, that they are not making a moral judgment. That if they are in the middle and they permit it for some and not for others, that they're sort of straddling this line, that their hands are clean, that they're not making a moral judgment. And you say, of course they are.
Well, you think of things like Lincoln with Douglas saying he has no moral judgment to make about slavery. He thinks people should be free to choose it. And Lincoln said, you just made a moral judgment. If you thought something was wrong, we say it is wrong for some people to hold others as slaves. For whom is it wrong? Or with a moral voice, we'd say, what's wrong for anyone, for everyone? If you understood there was something wrong about slavery, you wouldn't say that people are free to choose it. So you have made a moral judgment. You've come to the judgment that slavery stands among the things not wrong. I think this came out in that same chapter, you remember, with the hearings in the Senate on fetal pain, where my friend Daniel Robinson this Dr. Berkowitz was saying that unlike Bernard Nathanson on the panel, he himself was utterly neutral, had no moral judgment on abortion. And Chairman Orrin Hatch said, but Dr. Berkowitz, you perform them. You perform them. If you perform them, you've already evidently reached the notion that there's something about abortion not wrong. You have made a moral judgment. Now you can see, we can imagine a sign on a covered wagon in the 1850s. If you're opposed to slavery, don't buy one, But don't impose your religious convictions on anybody else. Yeah, that's one of the interesting things fallacies people fall into because they really just haven't grasped the logic of a moral judgment. As John Stuart Mill says, we stop using language of like and dislike. We start using the language of right and wrong when we move to the level of a moral judgment. We stop speaking about the things that are merely, we move away from statements of merely personal feeling and private taste. And we begin speaking about the things that are more generally or universally wrong. Scott, part of the argument here is that with you alert people to these precepts of natural law. What you hear often is, yeah, I think I've thought that all along. or it's like Plato's Meno. You draw questions, you give people the right questions, and you unlock what's already within them. You unlock what they know, and then they bring it out and they realize they've always known it. It's just a matter of bringing out the questions that alert them to what has been lurking there, which they haven't had the reason to think about.
Hadley Arkes, the book is Mere Natural Law. Let me close with this question. It's the final chapter in the book. After the overruling of Roe, the natural law moment, and you write about this matter on abortion being returned to the states. This grave moral question is put in the hands of a self-governing people, but you make this great point that when detached from the moral ground that would justify laws to ban abortion, those laws are naturally seen by their opponents as the flexing of brute power alone. So why is now the time for that moral ground to rise again? Why is now the time for natural law to emerge?
Well, I guess natural law carries the tradition that's long been contained in the notion of law. Again, is it enough to just seize power over others and expect your edicts to be respected as law? Or do we understand that we're passing a law? It's binding on people. It commits people even who would disagree with it. It displaces your private freedom, closes down private freedom, displaces your private choice with a public rule. Now, the traditional understanding, the moral understanding, the natural law understanding is that sort of affair, that sort of a situation calls out for justification. What is the ground on which you are justified in imposing a law on someone that restricts his personal freedom? That is, we're enjoined to explain what is this about this rule that we think is valid and rightful and therefore deserves to be binding even on people who disagree with it. So let's say we come out with a critical point. No, we do not hold people blameworthy for acts they were powerless to effect. If Jones couldn't, incapable of committing, we won't hold him responsible, won't prosecute him. Now, something like that, everyone understands it's a necessary truth. When you can come up with something like that, you say, I have hold of something which I am fully confident is true of necessity, and we have no warrant, no reservation about making that position binding, even on people who haven't seen it yet. We hope then the law may have some effect of teaching people. This is how the law engages in moral teaching. They tell you this is something so important that we really are removing it from the matter of personal taste because we think it is wrong for anyone to do. And this was the problem with Roe versus Wade and this attempt of the court to start undoing it. Roe versus Wade did not really establish a right to abort. It established there's something rightful and good about it. It changed the culture. It changed abortion from something to be discouraged, forbidden, into something to be approved, celebrated, promoted. It's a moral judgment. The court in Dobbs did nothing to touch that. All the conservatives thought they had to do was overturn, say this was not within the authority of judges to proclaim this. We send it back to the states. But we say nothing about the human standing of the child in the womb. So you're sending it back to the states. And a woman there who wants to divorce and says, you're sending it back to the states. Here's something I thought was important to me. And you're telling me I can't have it if 51% of people around me think it's a human life. And so what this looks like arbitrariness. So things would have moral standing as we impute value to them. How valuable is it to you to treat that child in the womb as a human being?
Hadley Arkes, thanks for joining us on the Radio Free Hillsdale Hour. Up next, we talk with David Azerrad from Hillsdale in D.C. about the preamble to the Constitution. I'm Scot Bertram. This is the Radio Free Hillsdale Hour.
Hey there! Today I want to tell you about the Hillsdale K-12 Classical Education Podcast. This unique show explains how children benefit from an American classical education. Whether you're a teacher, student, or parent, you'll find something of value on the show. You'll hear from teachers and administrators from schools around the country, as well as Hillsdale professors and friends who are leading the effort to revive the American tradition of K-12 education. When you listen, you'll learn all about classical education, what it is, how to teach it, and why it matters today. And there are dozens of back episodes on specific topics, like teaching Singapore math, reading great books, and even understanding how athletics is critical to a child's development. Listen every Monday on podcast.hillsdale.edu. That's podcast.hillsdale.edu or wherever you find your audio.
Welcome back to the Radio Free Hillsdale Hour, this special edition focusing on the United States Constitution. We continue our Independence Day episode of the show with Dr. Azerrad, talking specifically about the preamble to the Constitution. Dr. Azerrad, I'll simply read the preamble. It's not long. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. One sentence, David, and you say it explains our mission statement. How can one sentence mean so much?
Well, one is, you get the 6 aims for why we, the American people, decided to change constitutions. We sometimes forget this and the pride we have in having the oldest written national constitution still in continuous use in the world, is that it's our second constitution. And we first had the Articles of Confederation. And they did not work out. And so we had this second constitution. And it lists, I think, very nicely the, 6 aims of the American political community. There's a lot to be said about that. You see that, for example, you can see what is left out. One of the goals is not to save souls, because America is not a theocracy. Clearly, we have a robust tradition of religious liberty and provided ample space for people to worship God as they see fit, but we don't view it as the task of the political community to get you into heaven. That's something that you do on your own. what I really love, there's a lot we could talk about. This focus on the general welfare, on creating a more perfect union. This points to the defects of the Articles of Confederation, that the union was too loose. The words that really speak to me the most and that I find most admirable is the last and sixth reason, to secure the blessings of liberty to ourselves and our posterity. And that, to me, is the real standout that I think is the most concise, clearest, and beautiful articulation of why America exists.
You point out in the piece, David, that the Constitution, the preamble, distinguishes between liberty and its blessings. So they are not one in the same. Where do we see that perhaps manifest itself?
Yeah, so, America is the land of the free, and freedom and liberty, generally the same word. One has Latin roots, one has Germanic roots, are been rallying cries throughout American history. By the way, as a quick aside, it's interesting to note that the Washington Post recently noted that freedom is a white supremacist term, because it's been one of the rallying cries of the Canadian truckers. So just goes to show you where the elites are in terms of being completely unmoored from reality, that freedom is now a racist term for them. But what can you say in response to that? I think, however, it's important to remember that there's a difference between liberty and the blessings of liberty. And so clearly you can't have the blessings of liberty without liberty. But then it's also the case that not all uses of liberty will yield blessings. So to put it in more polemical terms, America was not a libertarian nation. There was no sense that, consenting adults can do whatever the hell they want so long as they're not aggressing someone else, on the grounds that, well, it's a free country, you can do what you want. So I think the founders would find laughable the idea that hard drugs are part of the blessings of liberty, or that widespread sexual addiction and immorality are part of the blessings of liberty. So again, they were not founding a theocracy. Libertarian would say, what are you talking about? The government shouldn't be in the business of regulating morality. To which I almost want to say, well, what do you want the government to regulate if not morality? You want the government to regulate aesthetics? You want the government to regulate theology? Of course, the reason we set up a government is to set up moral laws. The only issue is, what kind of morality do you want to regulate and legislate? So the libertarians want libertarian morality regulated, basically the non-aggression principle. I, as a conservative, would respond, I take my bearings from the founding, I would want a conservative morality that, of course, is attentive to the importance of liberty, but is not blind to the fact that some uses of liberty do not yield blessings, and as such, either should not be promoted or in some cases should be forbidden, and that is not a violation of what it means to live in a free country.
David Azerrad with us, talking about his piece at the Washington Times, The Constitution's Preamble Explains America's Mission Statement. You explain that these blessings of liberty don't belong to us, but to our posterity, meaning the next generation. We can't squander them. We give them to the next generation. We are, in the country, experiencing a fertility, I don't want to say crisis, but a problem, right? 1.64 children per woman, you point out, which is well below the replacement rate. We have fewer children overall. We have fewer families with children. Does the fact that many of us perhaps are not thinking about posterity, perhaps not thinking about the next generation, change many of our perspectives on this?
Yeah, and Scott, you shouldn't hesitate to use the word crisis. The fertility rate is at an all-time low. If it's any consolation, every single developed nation in the world but one has a fertility rate below replacement. The lone exception is Israel. Many are much worse than us. So, Ukraine is now in the news, and we don't need to get into this, but, their fertility rate is 1.2. This is basically a people signaling that they no longer care about sustaining and preserving their way of life. So what I love about that statement in the preamble is not just the distinction between liberty and the blessings of liberty, but it's this idea that the blessings of liberty are not just for us, but for our posterity. That American individualism is in our DNA. The Declaration teaches us that we're individuals with rights. We don't need to be taught to think of ourselves as individuals. I think what the Constitution does is it reminds us that, yes, we're individuals, but we're also part of a people. And as such, we're custodians. We're trustees. We did not build America. We inherited it from our forefathers, who in turn inherited it from theirs. And our task is to transmit it to the next generation, to raise them in such a way that they too will be capable of enjoying these blessings and passing them on in turn. And it's a very important reminder, as I said, because it a little bit cuts against the American ethos, which is very individualistic, and that's good in many ways, but it's important to remember the need to think intergenerationally, to view ourselves as links in a long chain of generations that are intertwined one with the other, and each one, if you want, you could say, inherits from the forefathers the country and is tasked with transmitting it to the next generation, which means on the one hand, there has to be a next generation. You need to have children, but then, of course, you need to raise them in such a way that they are capable in turn of transmitting this, of being Americans in the best sense of the term.
David, when we look at the mission statement, this preamble, and the fact that it does specifically say, secure the blessings of liberty to ourselves and our posterity, if we look deeper into the document, in what ways does the Constitution then work to secure these blessings?
Well, I think the biggest way is, look, you remember, the Constitution creates a federated republic. It's really about delineating entrusting certain very limited powers to the national government. You can read about them in Article 1, Section 8 of the Constitution. But then in simply placing some limits on what the states can do, but otherwise leaving them fairly free with a lot of latitude and much greater powers than anything the national government could have. And so you're not going to find explicit discussions of this in the Constitution, because you could say a lot of it will take place in the reserved powers of the states.
Final question for David Azerrad, his piece at the Washington Times, The Constitution's Preamble Explains America's Mission Statement. David, have we done a good enough job of educating our youth, our future generations about liberty so that they can recognize the ways that it is under attack and being chipped away at these days? Have we done a good enough job?
Well, clearly no, but I feel bad. I'm only 43, and here I am going to sound like one of these old fogies who's lamenting the kids these days. But I mean, you look at the history that is being taught about our country, it basically boils down to, and I'm, painting in broad strokes, but it's not entirely incorrect, that America was racist, and with a side heaping of sexism and homophobia. And that America today is maybe a little bit less racist, but it's still pretty darn racist. And the end result of that is, one is it completely minimizes or even denies the greatness of the past. And it makes people develop contempt for their country. I mean, why would you want to transmit this? Why would you want to fight for this? Why would you want to sacrifice on behalf of a political community that is so unjust? So they claim. So, I think history ideally would instill in citizens an admiration and a sense of gratitude for their country. You could say at the highest level, you'd want a history that makes men willing to die for their country. And the history we have today is really one that instills in whites a sense of guilt, in non-whites, in blacks in particular, a sense of deep resentment, and frays the civic bonds that should unite us all, and makes our country and its great past worthy of contempt.
Dr. David Azerrad, he is assistant professor and research fellow at Hillsdale in D.C. You can find his essay over at WashingtonTimes.com. The Constitution's Preamble Explains America's Mission Statement. David, thanks so much for joining us here on the Radio Free Hillsdale Hour.
Always a pleasure. Thank you.
That will wrap up this special Independence Day edition of the Radio Free Hillsdale Hour, focusing on the U.S. Constitution. Our thanks to Ronald Pestritto from Hillsdale's Politics Department, Hadley Arkes, and David Azerrad from Hillsdale in D.C. Remember, you can hear new episodes every week on this station. You also can find extended versions of some of our interviews or listen anytime to the podcast. Find it at podcast.hillsdale.edu or wherever you get your audio. Until next week, I'm Scot Bertram, and this has been the Radio Free Hillsdale Hour.